Good evening. I'm Robert Temmink. I'm one of the barristers here at Quadrant Chambers in London. I specialise in commercial litigation and international arbitration. This is my QBiT talk entitled, What is the Rule in Henderson and Henderson? So what is the Henderson principle? First, it's a procedural rule, and it's easy. Its purpose is to require and enforce finality in litigation, and the principle is this: that a second claim which seeks to advance a cause of action against a party which could have been brought in earlier proceedings may be found to be an abuse of the court's process and may be struck out without a hearing on the merits. So there are four important features of this doctrine, I think. First, just because a claim could have been raised in earlier proceedings doesn't necessarily mean that it should have been, because a party relying on the doctrine has to cross both of those hurdles. So that's an important point to remember. Secondly, whether a claim should have been brought in earlier proceedings involves a consideration by the court of a wide range of things, a broad merits-based judgment. Thirdly, the burden of establishing abuse is on the party alleging it, and that party usually has to show unjust harassment. And then finally, in these four principles of the Henderson rule, it's not a defence in itself, but it's a procedural objection to an action being brought at all. And there's good support for that in a speech by Lord Sumption in a case called Virgin Atlantic Airways and Zodiac Seats. So have we got any help on what counts as whether or not you should have brought a claim before? We have, and again we turn to Lord Sumption. He helps us with the legal test about the should-have element of this rule. He said the should in this formulation refers to something which the law would expect a reasonable person to do in his own interest and in that of the efficient conduct of litigation. And he said that in a case called Takar and Gracefield Developments Limited. So what about this abuse part of the test? What is abusive? There will rarely be a finding of abuse unless the later proceedings involve what the court regards as the unjust harassment of a party. So what does unjust harassment mean? Well, again, we've got this cascade of terms. Well, what it really means is impropriety or culpable conduct on the part of the claimant. It's something like a deliberate decision to hold a cause of action up your sleeve and then to raise it with a flourish after the first trial has taken place and everybody thinks the proceedings are done, dusted, and say, ha, but we're also going to sue you for this. And the authority for that proposition, because everything I tell you is supported by authority, comes from the judgment of the Court of Appeal in a case called Aldi Stores Limited and WSP Group. On abuse, let's not forget, it can be sensible to pursue different claims in different proceedings. For instance, trying to sue an excess layer underwriter of insurance rather than bringing claims against the insured. Let's say the insured looked to be insolvent. There's usually no impropriety where the claimants try to steer a path through complex or even reasonably complex commercial litigation. And what the courts say is where somebody, let's call them A, has brought an action against somebody else, B, a later action against B is much more likely to be held as an abuse of process than a later action against somebody else, C. And, of course, there is a real public interest, not only in the efficient conduct of litigation and the allocation of court resources, but also allowing parties a measure of freedom to choose who they sue, when they sue, and to make sensible, commercial, pragmatic decisions in commercial litigation. So let's look on the other side of the coin now. What happens if you're feeling harassed in litigation? Well, first, you need to think about whether this is a second claim you're facing arising out of the same facts. So are you actually being vexed a second time, or is this just generally vexing? If you think that abuse of process is the right remedy for something you're facing, then you need to ask yourself, could this claim have been brought before? Should this claim have been brought before? Am I being harassed? Is there a reasonable excuse for not bringing the claim on the first occasion? Has new evidence arrived? Was it a commercially reasonable option to pursue the claims separately? And if the answer to all those questions is yes, this is really abusive, then make an application. And when do you make it? You can make it at any time you like, but it's better to make it early, and you can make it before you even file a defence. In Fairclough Homes Limited and Summers, the Supreme Court said that there was, of course, jurisdiction to strike out a claim during a trial or even post-trial, but that jurisdiction is really rarely exercised. And it's rarely exercised because if you've gone to all the bother, and the court's gone to all the bother, and the judge has gone to all the bother of listening to all the evidence, they may as well make a judgment on it and say, no, the claim doesn't run. So speaking of claims succeeding, what about Henderson rule applications? Do they succeed? Well, rarely. And they rarely succeed because the applicant has to show that it's manifestly unfair to face a second claim. The courts are, rightly, reluctant to strike out a genuine claim unless there's genuine abuse. We've already seen that the principle can apply even where the second claim doesn't involve the same parties, though it's hard to see how a party can be twice vexed if they've never faced a claim from that party before. They haven't even been once vexed, whatever once vexing is. Unless the second claim is completely hopeless, we know that it's only in extreme cases that the court will consider the merit of the second claim. And even if there's a delay in bringing the second claim, that too usually isn't relevant. But you can imagine, I'm sure, that there are circumstances where delay might be relevant. Imagine all of the witnesses have died, all the relevant witnesses, and can no longer be presented to give evidence on behalf of the poor second vexed claimant. What about keeping your cards up your sleeves? Well, the Court of Appeal has developed what we now call the Aldi guidelines after the Aldi case, and they say a claimant should disclose the possibility of a second claim in the first action, and they should do that so the court can decide how to manage that second claim itself. So it can give direction, so it can decide whether to hear the claims together, where to hear them one after the other, or not. So that is a broad overview of the rule in Henderson and Henderson in 10.